In a recent case, Supreme Court Justice Clarence Thomas has articulated not only his concerns about the enormous, virtually monopoly power enjoyed by digital media platforms, but also shown a legal pathway to how those platforms can be restricted or regulated. Regulated in this case not to limit the access to free speech, but in fact to promote it. Now, the case that Thomas is commenting on was actually a case that is sort of moot. It's a case which was brought by people who had been blocked by President Trump on Twitter. And these people go, the president is a public figure, he doesn't have the right to block me. So this case wound itself up to the Supreme Court and ironically reaches the Supreme Court when Trump is no longer the president. So the Supreme Court in its decision goes, well, this is kind of a moot point. But Thomas, in considering the issue and in considering the underlying issues, realizes that there are issues raised by all this that are very pertinent today, even though Trump is no longer in the White House. The first thing he says is, look, it's kind of funny that the plaintiffs in this case are saying that public figures should not have the right to block them, when Trump himself has been blocked on Twitter. Trump is off Twitter. And so what kind of a public forum is it for Trump when Twitter itself, a private company, gets to decide if the public figure can even be on Twitter in the first place? And then Thomas takes the discussion to a much more general level than the specifics of the Trump case. He goes, today's digital platforms, he talks about the fact that they have unprecedented concentrated power. Also unprecedented is the concentrated control of so much speech in the hands of a few private parties. We will soon have no choice but to address how our legal doctrines apply to highly concentrated, privately owned information infrastructure such as digital platforms. Now, of course, it's been a libertarian argument for some time that these are private platforms and they have every right to do what they do. But, as Thomas points out, wait a minute, all kinds of private platforms are in fact regulated. Radio stations are regulated, television stations are regulated, and the reason that they're regulated is that they involve the public airwaves. They involve, if you will, the public space. Now, some of those who claim that these are private platforms that don't have monopoly power make the argument that, well, you know, even though Facebook may be so dominant in this particular space, or Google or Twitter, there are some alternatives. People do have other options. But Thomas goes, that argument doesn't really fly. He goes, it changes nothing that these platforms are not the sole means for distributing speech or information. And then he gives this example. A person always could choose to avoid the toll bridge or train and instead swim the Charles River or hike the Oregon Trail. But in assessing whether the company exercises substantial market power, what matters is whether the alternatives are comparable. For many of today's digital platforms, nothing is. So the point being, if you're trying to decide if a toll booth is controlling the traffic across a river, you can't say, well, gee, you know, yeah, we are, but the guy can always swim. No, that's not a practical or practicable alternative. Thomas goes on to make the point that he's talking about Google here. And he says that when a user doesn't know where to find something on the internet, and users rarely do, Google is the gatekeeper between that user and the speech of others 90% of the time. Similarly, Facebook and Twitter can greatly narrow a person's information flow through similar means. And then he talks about Amazon and says that a clear majority of ebooks and about half of all physical books are controlled through a single distributor, Amazon. Now let's remember that Amazon is precisely the company that removed the Clarence Thomas documentary during Black History Month. They also censored a book by Ryan Anderson. His book is called When Harry Became Sally. It's kind of a critique of the transgender movement. Very interestingly, if you go on Amazon now and you search for that book, you get a book with the opposite point of view. In fact, you search that book and what comes up is Let Harry Become Sally, responding to the anti-transgender movement. So this is a clear case where Amazon is rigging the search. So you're finding not the book you're looking for, but a book conveying the exact opposite message of what you're looking for. And Thomas's point here is that these are, in his word, quote, common carriers, and they are also, quote, places of public accommodation. And what Thomas is getting at here is that when you're dealing with common carriers, the phone company, places of public accommodation, let's say a hotel, they don't have a right to exclude people. So you can't go to a hotel and they say, hey, listen, you know what? We don't like the way you look. You can't get a room here, even though you're following all our other rules and you're willing to pay. Or if someone goes to a restaurant, you know, we don't really like Latinos. You can't really eat here. Sorry. No, yes, you can. So what Thomas is getting at is when you're dealing with common carriers, just as the phone company can't refuse service arbitrarily, just as a hotel or restaurant can't just turn people away, they can establish certain types of rules, but the rules have to be uniformly enforced. The bottom line of it is, what Thomas is laying out here is a legal rationale for the government, either at the state level or at the federal level, coming in and saying to these carriers, if you want to operate in our state, you're going to have to respect the free speech of all our citizens.